The parties agree that there's been no issues relating to family violence. There's no request for non-disclosure. The non-custodial parent,
Welcome back to the channel, folks, and buckle in because today's courtroom session is packed. We're talking child support deviations, custody disagreements, arrears battles, tax credit disputes, visitation conflicts, smoking allegations, and even a temporary order involving an incarcerated father. Across multiple cases in a single docket, we're watching real parents navigate the emotional, financial, and legal fallout of co-parenting under pressure. Some parents are forgiving thousands of dollars in arrears, others are pushing back against guideline support, and judges are stepping in hard when testimony gets inconsistent. Stay sharp and let me know in the comments, which case grabs your attention first.
is currently employed as a hairstylist with a gross income of $2,700 per month with no additional minor children. The parties agreed to confirming the child support arrears in the amount of $3,512.25. The custodial parent is requested to release all arrears. Judgment after arrears is $0. The parties agree as it relates to medical support that the child is currently insured through the custodial parent's employer at $81. However, the party is not requesting any reimbursement. As it relates to the confirmation of arrears for medical support, the state has calculated medical support arrears in the amount of $1,183.45 as of October 26, 2025. The custodial parent is requesting to release all arrears, court costs billed to the non-custodial parent. The only issue before the court at this time, Your Honor, is the issue relating to child support. So the state will request to take additional testimony on that issue alone. So at this time, Your Honor, the state would like to call the father here in this matter. Sir, can I get you to state your name for the record?
Mark Beasley.
And just to confirm, sir, the child here in this matter is currently residing with you.
It's 50-50. He's with his mother at the moment.
All right. In the prior order, the child was to reside with you primarily. Is that correct?
Yes, I was the primary custodial parent, yes.
All right. Sir, did you hear what I previously read into the record as it relates to the agreements here in this matter?
Yes, I was kind of unsure
Mr.
about the
Beasley?
child support.
Mr.
Can you hear me?
Beasley, can you
Yes,
just answer the questions that have been provided to you, sir?
yes,
All
I
right.
heard you.
Thank you, sir. Now, as it relates only to the things that have been provided to you that were agreed to, sir, did you hear what was read into the record?
Yes,
Are you in agreement with those terms that were provided to the court?
yes,
Are you requesting that the court accepts those agreements and make them part of the order today?
yes,
As it relates to the issue of child support, sir, based off of the mother's income, the state will request that child support be set at $439. However, you are requesting that child support be set at $0. Is that correct?
yes, correct.
And could you explain to the court why you're requesting to deviate from the guideline child support amount of $439 to $0?
Because we pretty much take care of the kid evenly. It's joint custody. We've been splitting payments as far as extracurriculars, medical bills, and she's been doing a great job at just uh, supporting the child. So I don't see the need to.
Okay, pause here. This is a key moment. The father is asking the court to drop child support from the guideline amount of $439 all the way down to $0. That is a massive deviation request. And his reasoning? He says they split custody evenly and both parents contribute directly to the child's expenses. Now here's the catch. Even with 50-50 custody, courts typically still require support unless both incomes and parenting time are nearly identical. He's also forgiven over $3,500 in arrears, which is a huge gesture in family court. What do you think? Is he being generous or overlooking long-term financial structure for the child?
Ask for more.
All right, Mr. Beasley, you provided that there is a split custody as it relates to who the child is residing with. What days does the child reside with the mother, and what days does the child reside with you, sir?
So the first, third, and fifth week, he comes to me on Wednesday and goes back to her on Saturday. And then on the second and third week, it's Tuesday. He comes to me and he resides with her on Saturday. Goes back with her on Saturday.
So
So,
the mother has the child from Saturday to Monday.
okay, I'm sorry, I might have confused that. So from Tuesday, how's that? So I just remember I get them on get them either Tuesday or Wednesday each week, and then I take him back to his mother on Saturday.
Thank you, sir. Is there any other reason why you believe that the child support should be set at $0?
No, that's pretty much it.
Right. And do you find that setting child support at $0 instead of the 439 would be in your child's best interest?
Uh, can you repeat the question?
Yes. Do you believe that receiving $0 instead of the 439 would be in your child's best interest?
Correct.
And could you explain to the court how so?
Because I could take care of him financially when he's in my when he's with me, and then of course I don't want to take away anything from her household for when he's with her. Honestly, she if when it's needed, she'll assist and help out. So I don't see the need to ask for extra income or money.
And as it relates to you stating that the mother is helping out, however, she was not paying child support previously as ordered, is that correct? Or was she paying it directly to you, sir?
No, she wasn't paying it directly to me. It was through the OAG.
However, at this time, when we calculated today, she still owed $3,512.25, but you requested to forgive that amount. Is that correct?
Yes, correct.
All right. Nothing further from this party owner. At this time, Your Honor, the state would like to call the mother here in this matter. Miss Kidd, can I get you to state your name for the record?
Shalice Kidd.
And Miss Kidd, did you hear what I previously read into the record that was agreed to by the parties?
Yes.
And are you still currently in agreement with those terms?
Yes, sir.
Are you requesting that the court accepts those agreements and make them part of the order today?
Yes, sir.
As it relates to the issue of child support, the state is requesting that you pay a total of $439 for child support. However, you are requesting to deviate from that amount, setting child support at $0. Is that correct?
Yes, sir.
And could you explain to the court why you're requesting to deviate from the guideline amount of 439 down to $0?
Like Mark Beasley said, we do split custody. I take care of my child and his needs when he is with me, and he does the same when he has him in his possession.
And on what days do you have the child in your possession, ma'am?
I get him every Saturday. One week on, I bring him back on Tuesday, and then the next week I'll keep him till Wednesday. So we alternate weeks like that. I get him every Saturday. He goes back Tuesday on one week and Wednesday on the next week.
Do you have any additional information you'd like to offer to the court at this time?
No, sir.
All right. Nothing further from this party owner.
All right, the part y'all agreed to, those are fine. And then for the child support, if y'all are splitting the child, I'll go ahead and set it at 0. The Attorney General's office is going to put that in writing. It'll take them a couple weeks to change the arrears amount. And that'll be it. That'll be your finalizing your case today. All right, y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
All right, thank you.
Your Honor, this appears to be a partially agreed order. The state is requesting to read into the record what has been agreed to by the parties. The parties agree that there's been no issues relating to family violence. There's no request for non-disclosure. The non-custodial parent is currently employed as a box truck driver with an average income of $750 per week. The father has 2 additional minor children outside of this case. The parties agreed to setting the medical support beginning November 1st, 2025 at $150 with the child or children here in this matter to be covered by the custodial parent employer, court costs to be billed to the non-custodial parent. That appears to be the things that are currently agreed to. We will need to take additional testimony on the issues relating to child support and arrears. So at this time, Your Honor, the state would like to call the mother here in this matter. Ma'am, can I get you to state your name for the record?
Robin Chamberlain.
Ms. Chamberlain, did you hear what I previously read into the record that was agreed to by the parties?
Yes.
And are you still currently in agreement with those terms only?
Yes.
Are you requesting that the court accepts those agreements and make them part of the order today?
Yes.
All right. As it relates to the contested issue of child support, The state is requesting that the father pay child support in the amount of $503 per month beginning November 1st, 2025, based off of his income. Are you in agreement to that amount, ma'am?
Yes.
And as it relates to the issue of arrears, the state has calculated that the father owes arrears in the amount of $14,200.80 for child support arrears and are requesting that the father pays a total of $121 per month towards those arrears until that is paid off. Are you in agreement to that amount?
Yes.
And as it relates to the issue of medical support arrears, the state has calculated that the father currently owes $2,108.14 as of September 30th, 2025, and requesting that the father pays that at $61 per month until that amount is paid off. Are you in agreement to that?
Yes.
All right. Do you have any additional information that you would like to offer to the court as it relates to the contested issues?
No.
All right. Nothing further from this party. At this time, Your Honor, the state would like to call Mr. Handy. Mr. Handy, can I get you to state your name for the record?
Tomorrow, Andy.
And Mr. Handy, did you hear what I previously read into the record that was agreed to by the parties?
Yes.
And only as it relates to the agreed terms, sir, are you still currently in agreement with those terms only?
As far as the child support or the
Sir, did you hear what I read into the record that was agreed to by the parties?
yes,
Are you in agreement with those terms only, sir?
yes.
As it relates to the contested issues of child support and the arrears here, we are going to take additional testimony on those issues. Do you understand, sir?
Here's another big turning point. The father is arguing that his arrears, over $14,000, should be reduced because he was supposed to claim the children on taxes every other year, but didn't get to. Now, from a legal standpoint, this is where many parents get tripped up. Tax arrangements in an order only matter when the parent has primary possession or specifically meets IRS dependency rules. Occasional weekend time doesn't qualify. And the judge is clear. Only payments made through the state system can credit arrears. Buying clothes or supplies voluntarily. That almost never counts. If you were the judge, would you consider his argument? Or deny it like the court ultimately does?
Yes.
As it relates to the agreed terms, are you requesting that the court accepts those agreements and make them part of the order today?
Yes.
All right. As it relates to child support, sir, the state is requesting that you pay child support based off of your income at $503 per month beginning on November 1st, 2025. Are you in agreement to that amount, sir?
No, sir.
Could you explain to the court why you do not agree to paying the guideline child support amount of $503 per month?
Because it's extra stuff I do for the kids, um like uniforms, anything. I get the kids every weekend. And I know child support say I get them first, third, and fifth, but sometimes I get them every weekend. It just depends on what work for everybody. So I don't think my child support should be raised. I think I would help with the insurance. I know I was supposed to the kids was on Medicaid, and I understand that they not. So yes, of course, help with that. But my child support shouldn't be rose because I do extra stuff.
All right. Thank you, sir. As it relates to the arrears, the state has calculated, sir, that you currently owe $14,200.80 for child support arrears
Hmm.
and requesting that you pay that at $121 per month until that is paid off. Are you in agreement to that, sir?
Um. No. I mean, I agree to the paying some of it back, but I was trying to see if some of it could get reinduced. Because some years I was supposed to carry the kids on income tax and I wasn't able to.
All right.
So I was trying to see could we cut the some of that down instead from like 14,000 to like at least 6,000.
All right.
So and I agree to pay some back because I was behind, but not all of it due to some stuff I couldn't carry the kids.
So just to confirm, sir, you're stating that you do agree that you owe the $14,200.80, but you're requesting that you be given a credit towards that amount to reduce the amount that you currently owe. Is that correct?
Yes, sir.
And sir, you're stating that you believe that you are due a credit because you were not able to carry the children on your income tax. Is that correct?
Yes, sir.
Do the parties have an agreement outside of the court order stating that you were to carry the children, sir?
Yes, it says every other year in the court order.
Okay. And were the children residing with you, sir,
It's the
primarily?
every weekend.
Were the children residing with you primarily, sir?
No, not primarily.
All right. As it relates to medical support, sir, the
Mhm.
state has calculated that you owe $2,108.14 and requesting that you pay that back at $61 per month as it relates to the arrears. Are you in agreement to that, sir?
Yes.
All right. Do you have any additional information that you would like to offer to the court as it relates to the contested issues before the court?
No.
All right. Nothing further from this party, Your Honor.
All right. For the parts y'all agreed to, those are all fine. Those are going to be part of the court order. Um, I can't reduce your arrears. I'm not sure what your order said before as far as the tax return, but I can only count what you actually paid and what you've paid through the child support office. If you paid it separately, like you bought stuff,
Hmm.
things like that, I cannot credit you with those things. I can only
Yes,
count
sir.
what you paid through. Please don't talk while I'm talking.
Okay.
I can only give you credit for what you paid through the child support office. I can't waive some part of the arrears or anything like that. You're supposed to pay it through the child support office, period. There aren't any other options. So if you don't do it that way, then you owe arrears, and I don't have any choice but to confirm them as they are. The judgment for child support arrears is $14,200.80, to be paid at $121 a month. And then the medical support arrears the same thing. I can't change it. That you're supposed to pay it through the child support office. $2,108.14, payable at $61 a month. Um, I mean, you don't have custody, y'all aren't splitting. Sounds like maybe sometimes you have a little more possession than the usual, but it's not consistent, is what it sounded like to me. So I really don't have any reasons to lower your support. If you want to buy schools close at the beginning of the year and pay it through child support, then we can credit you with that. But if you go to the store yourself, we have no way to track whether you do that or not. And so I can't give you credit for that. So if you want to do it that way, that's an option. But like I said earlier, we can't credit you with stuff that we don't see. And I don't know if those things are also consistent either. So we have to have a consistent and really clear child support order. It can't vary based on 1 month or this month or doing something. Maybe this month you didn't do anything or vice versa. So we have to have a set amount based on your income. It's 503. So I have to go with that number. That's the number that you got to pay for child support. Um, all right. So the attorney general's office is going to put all that in the court order, email you both a copy. You're both done with court. You can press leave on the Zoom to exit out. Thank you.
Thank you.
The parties agree that there's been no issues relating to family violence within the last 2 years. The parties agree that there shall be no non-disclosure of information. The parties agree that the non-custodial parent is currently employed at $13 an hour full-time with an additional $250 commission per week, that the father has no additional children. Based off of the reported income, the state is requesting and the parties are in agreement to setting child support at $554 per month and medical support through the state at $225 per month. The parties to be named as joint managing conservators with a residency restriction to Dallas and the surrounding counties, with court costs billed to the non-custodial parent. The contested issues today, Your Honor, are the issues relating to retroactive support and visitation. So at this time, Your Honor, the state would like to call the mother here in this matter. Ma'am, can I get you to state your name for the record
Albany Davis,
and the name of the child or children that we're here in reference to,
Peoria Kinney,
and the name of the child's father,
Darius Kinney,
and the age of the child?
9 months.
And did you hear what I previously read into the record that was agreed to by the parties?
I couldn't quite hear you, excuse me.
Yes. Did you hear what I read into the record that was agreed to by the parties?
Yes,
Are you still currently in agreement with those terms that were provided to the court?
yes,
Are you requesting that the court accepts those agreements and make them part of the order today?
yes,
All right. As it relates to the issue of retroactive support, are you requesting retroactive support for the child here in this matter?
yes,
The state has calculated retroactive support without any credits in the amount of $5,540. And if that amount is to be ordered by the court, the state will request that the father pays that at a total of $78 per month. In the past 10 months, how much money, if any, would you state that the father has provided you for support of the child?
He doesn't give me money. He'll buy the items, and I would say the items will be adding up all the items. It'll be around like 150 or something.
So are you requesting to give the father a credit of $150?
Yes.
All right. With a credit of $150, the state will request a judgment in the amount of $5,390 to be paid at $77 per month. Are you in agreement to that amount?
Yes.
All right. As it relates to the issue of visitation, has the father had any visitation here recently with the child here in this matter?
Yes, he seen her yesterday.
All right. Has the father had any overnight visits with the child?
One. He stayed the night with us.
All right. And is there any specific reason why the father hasn't had any overnight visits at his home?
Yes. Um, so there is a few reasons. One reason is they smoke around my child, which I'm not okay with. They don't have any furniture. They don't have anywhere for the baby to sleep, and there's also a large animal there that I'm not okay with being around her. I actually have a whole list. I've been documenting everything. Let's see,
Is there any other reason other than what you provided?
1 second. Yeah, so they don't have any they don't have anywhere for her to sleep, and they smoke in front of children.
All right. Are you requesting that the father has visitation with the child every other Saturday from 12 to 5 p.m.?
Yes.
And that'll be on the first, third, and fifth Saturdays of each month?
Yes.
And are you requesting that after the child turns the age of 2, that the father would then have a standard possession order?
Yes.
All right. And as it relates to the court costs, the state is requesting that the father pay the court costs in today's hearing. Are you in agreement to that?
I couldn't hear you.
Yes, ma'am. The state is requesting that the father pays the court costs associated with today's hearing. Are you in agreement to that?
Yes.
All right. Do you have any additional information that you would like to offer to the court?
I actually have a whole like notepad. Is there a way I can send it?
So, ma'am, is there any additional information that we have not addressed that you're requesting to provide to the court at this time? And if there is, could you provide that information via your testimony at this time?
1 second. No.
Yes. Nothing further from the state, Your Honor, from this party. So at this time, Your Honor, the state would like to call the father here in this matter. Mr. Kinney, can I get you to unmute yourself?
I'm muted.
All right, Mr. Kinney, can I get you to state your name for the record?
Darius Kenny.
And Mr. Kinney, did you hear what I previously read into the record that was agreed to by the parties?
Yeah.
As it relates only to the items that were agreed to, are you still currently in agreement with those terms only, sir?
Nope. I still want to see my child Friday, Saturday, and Sunday.
Sir, again, I read things that were agreed to and things that were not agreed to. My question is only to the things that were agreed to, sir, that you stated that you heard me read into the record. Are you in agreement with those terms only?
Sure.
All right. As it relates to the issues that are not agreed to, sir, we're going to take additional testimony at this time on those issues. As it relates to the issue of retroactive support, the state has calculated retroactive support for 10 months in the amount of $5,540. The mother is requesting to give a credit in the amount of $150. Thus, the state will request a judgment in the amount of $5,390 to be paid at $77 per month. Are you in agreement to that amount, sir?
Yeah.
Just to confirm, sir, you're stating that you do agree to paying the retroactive support as provided to the court.
Can you repeat that?
Mr.
Yes, I'm
Kinney,
just
I don't know why you're muting yourself and why you're walking around during court. I need you to answer the questions and not stop talking to other people that are in the room or whatever it is you're doing. Go ahead.
You
may,
repeat the question.
may I proceed, Your Honor?
Yes, Mr. Tatum, go ahead.
Thank you, Your Honor. As it relates to the issue of retroactive support, you just provided to the court that you do agree to the amount of $5,390 to be paid at $77 per month. Is that correct, sir?
Yep.
All right. As it relates to the issue of visitation, the mother is requesting that visits take place with the child on Saturdays from 12 to 5 on the first, third, and fifth Saturdays of each month. Then you transition into a standard possession order when the child is age 2 years old. Are you in agreement to that, sir?
No.
All right, sir. Could you just tell the court what you're requesting that the visitation schedule will be?
Friday and Saturday, Sunday, and just like she taking my daughter over there to her granny house and her mama and her auntie and her other people that's in Paris.
Sir, could you just tell the court what you're requesting the schedule will be?
Friday, Saturday, and Sunday.
From what time, sir?
12 to 8.
All right. Have you previously had the child during those time frames from 12 to 8 previously, sir?
No, we could start with 12 to 5, but I most definitely want 12 to 8.
All right. And at what time do you believe that the child should transition into the standard possession order, sir? At what age?
1. Now,
Do you have any additional information you'd like to offer to the court at this time, sir?
yeah,
What is that, sir?
we share. Well, no, you said don't share personal information. I guess we can continue.
Nothing further from this party owner. We are requesting a ruling on the issue of retroactive support and the issue of visitation.
Just a second. Mr. Kinney, are you smoking around your child?
Nah, I ain't never smoked around my daughter. It's a baby in here right now, and we still don't have no smoke in here, boss man. I can't say the same thing about the cigarettes being smoked over there in the restroom, but that's another story for another day, I guess.
I don't smoke cigarettes in the restroom.
I'm not talking about you, boss man.
I'm asking you, sir.
Nah,
I
I'm
need
saying
to-
the party that threw that out there.
I ain't
But
asking
no,
about the other party. I asked you.
no, boss man. I ain't never smoked in front of my daughter,
Okay.
and they can't even show me evidence.
All right, let me go ahead and make a ruling. So it looks like you agreed on everything except for visitation. So we're approving all the agreements. There's a judgment of $5,390, payable at $77 a month. I'm doing a drug injunction. Neither one of you are to smoke or do any drugs or be under the influence of any drugs before or during your time with your child. There's to be no smoking around the child at all, any kind of smoking, even cigarettes. Um, and that includes even just being in another room. There shouldn't be any smoking around the child. We're gonna do visitation the first, third, and fifth Saturdays and Sundays. I'm gonna make it from 12 to 6. So it's not gonna be just Saturday, it'll be Sunday as well. It'll be from 12 to 6 until the child is 2, and then standard visitation. The standard visitation will be the every other weekend from Friday at 6 until Sunday at 6. So that'll expand the visitation, mainly doing that because of the age of the child and because there haven't been too many overnights so far. All right, that'll be the order that y'all must follow. The Attorney General's office is going to put that all in writing, email you a copy. You're done with court. You can press leave on the Zoom to exit out. Thank you. All right, Mr. Key, you want time to hire an attorney?
Yes, and I told her that wasn't really, I needed a little bit more time than December 1st.
Okay, well, that's about a little bit over a month. We can't reset it over and over again. Your case is probably not very difficult. It's pretty easy.
No,
It's a
that's
question of how much
fine.
you
That's
owe.
fine.
And
I just got some discrepancies with some of the numbers, but that's fine. December 1st is fine. I
okay,
just need to get somebody to look over this stuff.
make sure you look at the pay record and make sure it matches with what you've paid or not paid. That's really all we need. I only have one issue. You have like the simplest case today. It's just a matter of how much you owe and how much, and if you owe something, how much you got to pay it back at. That's pretty much it. So if you want to review the pay record, that's the most important thing to do, uh, compared to what you've paid through your check or you pay send in and see if there's any issues where there were missing payments. They might not be the exact dates that it got taken out of your check, but it should be around the same date. And
But
then
some of the numbers he gave me that I was paying, and it's not, it's a lot more than and she couldn't really break it down and explain to me why I was paying more than what was set up.
if
And
you
I
were
got the
behind,
arrears and all that, but
if you were behind, that's why you're paying more. But look at the
what?
pay
No, no,
record.
no.
I'm
I
not
get.
trying to solve it right
I
now. I'm not trying to argue with you. I'm just
no, I'm
telling you,
not
look at
either.
the pay
Obviously,
record.
that's why I want
Stop
to get
talking
it
while I'm
calculated.
talking. Stop talking while I'm talking. Trying to help you, but you're talking over me. Look at the pay record, make sure that it's correct. If there's an issue, talk to the Attorney General's office before court. If you want to get an attorney, that's fine. We're going to reset your case at December 1st for you time to get an attorney if you choose to, or even just to prepare your case. I will probably not grant you another reset on December 1st. So make sure that you are ready. And that's what I'm trying to tell you to do so that you can be ready. Even though you keep talking over me, you're not listening to me. Look at the pay record, make sure that you understand what it says. And if there's a problem, then you need to be able to point out to us what's wrong or what's missing if there's something that's missing. All right, you're done with court. You both can press leave on the Zoom to exit out. See you in December. Bye bye.
Your Honor, the state is requesting that the court take note of the service on the non-custodial parent and requesting to proceed with a default at this time.
Go ahead.
Thank you, Your Honor. At this time, Your Honor, the state would like to call the mother here in this matter. Ma'am, can I get you to state your name for the record
Norma Rivers,
and the name of the child or children that we're here in reference to,
Zacchaeus Dr. Kazee McKinney,
and the name of the child's father?
Breon McKinney.
Is there any other person that could possibly be the child's father other than the person that you previously named?
No.
And are you requesting that he be named as the child's father per court order today?
Yes.
Has there been any issues relating to family violence between you and the other party to this case?
No, sir.
And are you okay with the other party having your information, such as your address and telephone number?
Yes, sir.
And are you requesting that you and the other party to this case be named as joint managing conservators for the child here in this matter?
Yes. Yes.
And do you agree to reside in Dallas and the surrounding counties with the child?
Yes.
And as it relates to visitation, has the father had any visitation with the child here recently?
Yes. So we kind of have a system for already. He kind of gets him every other weekend. Sometimes he'll get him 2 weekends in a row, but majority it's every other weekend.
Right. Are you in agreement for the court order to reflect that the father shall have a standard possession order as it relates to visitation going forward?
Yes.
Right. The state has used the reported income of the non-custodial parent at $2,540.16 as a gross income, giving credit for one additional child. Based off of that information, the state will request that the father pays state medical in the amount of $114 per month. Are you in agreement to that amount?
Yes, sir.
And child support in the amount of $368 per month. Are you in agreement to that amount as well?
Yes, sir.
And are you requesting retroactive child support?
Is that back child support? Is that what that's considered?
Are you requesting child support for the past 3 years, ma'am?
Yes, I am.
All right. The state has calculated retroactive child support in the amount of $13,248 and will request that the father pays that back at $125 per month. Are you in agreement to that amount, ma'am?
Yes, sir.
And just to confirm, the father has not provided you with any support for the child in the past 36 months. Is that correct?
Within like this past year, yes, he started, but for those other years, no.
So you stated that he's been giving you support from what time frame, ma'am?
2024 to 2025.
What month, ma'am?
Um, I'll just say January, from January 2024 to today.
All right, so I would need to recalculate, ma'am. Give me just a moment.
Hello?
So with that being said, what you just provided as it relates to the testimony that he has been providing support over the time frame of 2024, January to present date, the state has recalculated support and will request retroactive support only for 14 months at $368 per month. The state will request that the father has a retroactive support judgment in the amount of $5,152. Are you in agreement to that amount, ma'am?
Yes, that's fine.
And the state will request that he pays that back at $75 per month. Are you in agreement to that as well?
Yes.
And are you in agreement to the father paying the court costs associated with today's hearing?
Yes.
Right. Nothing further from this party owner.
All right, your default judgment requests are granted. The Attorney General's office will put this all in the court order and email you a copy as well as to him. And they'll try to send out withholding orders if they know where he's employed. You're done with court, Ms. Rivers. You can press leave on the Zoom to exit out. Thank you.
All right, thank you.
Azaria Van Zant.
And Ms. Van Zandt, you were previously ordered to take a DNA test with the child here in this matter. Is that correct?
Yes, sir.
And were you able to review those DNA test results today?
Yes, sir.
And did they provide that the other party in this matter is the child's father?
Yes, sir.
And are you requesting that he be named as the child father per the DNA test results today?
I'm sorry.
Yes. Are you requesting that he be named as the child's father based off of those DNA test results today? Is that correct?
Yes, sir.
All right. And there had been a prior finding of family violence, and you're requesting that that continues into this order. Is that correct?
Yes, sir.
And based off of that prior finding of family violence, you're requesting to be named as the sole managing conservator for the child here in this matter. Is that correct?
Yes, sir.
And are you requesting that the father has no visitation with the child?
Visitation. Okay, like he could see her, but everything's with me. He has to go through me.
And ma'am, the father is currently incarcerated. Is that correct?
Yes, sir.
And there's no current release date for that party. Is that correct?
Yes, sir.
As it relates to the geographical restriction as where the child will reside, do you agree for the child to reside here in Dallas and the surrounding counties?
Yes, sir.
And based off of the father's current incarcerated status, the state is requesting that both child support and medical support be set at $0. Are you in agreement to that?
Yes, sir.
And there's no request for any retroactive support. Is that correct?
What's retroactive?
Child support from the past, ma'am?
Yes, sir.
All right. As it relates to the incarcerated status of the father, do you have do you know when he's expected to be released?
Maybe in 3 months.
And is that just your assumption, ma'am?
Mm. I received a text message from, let me see who it was. It's the text messages say, I received a text message from Julian Kushner with the DA's office, and they let me know that Ricky is going to plead today and he will be on probation. And then I asked, when will he be getting out? They said he has to go to inpatient treatment first, which is for 3 months, and that was October 9th.
And are you in agreement to the state's request to waive the court costs associated with today's hearing?
I'm sorry.
Ma'am, the state is requesting to waive the court costs based off of the father's current incarcerated status. Are you in agreement to that request, ma'am?
Yes, sir.
Do you have any additional information that you would like to offer to the court as it relates to this matter?
No, sir.
All right. Nothing further from this party owner.
Ms. Van Zandt, we also have another option. We can do a temporary order if you think he's going to get out in about 3 months. But do you think he's going to go to a halfway house after he gets out?
No.
Okay. So I can reset your case maybe from 4 months from now. Go ahead and do a temporary order, and then we can readdress child support if he gets out before that next court date. Would you rather do that, or do you want us to just do a final order today, and then you'll just wait a little longer for us to modify the order for support?
I'd rather just, yeah, wait a little longer for y'all to modify, because I still want to go through with everything. So
Did you understand the two options I just explained?
no, not really, but
Okay, one, we do a final order like what was intended to do, and then you're gonna have to wait for him to get out. And then when he gets out, then the AG will have to file a new case. They'll have to go serve him. He'll have to come to court, kind of like starting over in a way. except that you'll have custody and all that part. But they'll have to kind of start over, or we can just do this as a temporary order and then come back in 4 months, and then we don't have to reserve him again. We don't have to ask the AG to restart their case or anything like that. We can just wait, and then once we confirm he's out, that even if we don't know if he's employed, we can set some support.
Okay, will I still have custody?
Yes, either way, you'll still have custody.
Yes, sir. I'll do the second option.
Okay, let's do that then. If it was gonna be more than 3 months, and I would say let's go ahead and do a final order, but um, let's go ahead and do that. That may help you better. Okay, let's pick a date about 4 months out, Mr. Tatum.
Yes, just one moment. The state will request a reset date of February the 5th.
Okay. All right. So we're doing a temporary order today. We're finding that he's a biological father, making a finding there's been family violence, appointing you as the one to decide primary custody under a sole managing conservatorship order. There's no visitation ordered at this time. We can readdress that later if you want, but he's not going to be able to do supervised visits with you if you have a protective order because he's not supposed to be around you. So if you want to think about some other alternatives that we could talk about in February, that maybe that's something we could talk about then, but you cannot supervise visitation if there's a protective order.
Yes,
No
sir.
child support or medical support at this time. Not going to make a ruling on, well, retroactive. I'm just going to set it at 0. Mainly, we're just coming back to see whether we're going to be setting child support or medical support. And the case is reset to February 5th, 2026, for final hearing. All right. Yes, Mr.
Your
Tatum.
Honor. The state will request to reserve the issue of court costs until the final hearing.
Yes, of course. Okay. All right, then you are done with court. You can press leave on the Zoom, Ms. Van Zandt. Make sure you carve out a little time for us in the morning. If you got to take the morning off when we have court in February, even though there's some waiting involved, we need you to be able to pay attention to.
And that wraps up this multi-case docket, a full spectrum of family court challenges. We saw parents negotiating child support, contesting arrears, disputing visitation schedules, and even addressing safety issues like smoking around a child. The judges consistently emphasized documentation, consistency, and adherence to official payment channels. Whether it was a parent forgiving thousands in past due support or another seeking more visitation despite inconsistent possession, the rulings reminded us that the court's priority is always the child's best interest, stability, safety, and structure. If you found these cases as shocking or eye-opening as we did, make sure to hit like, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.
What we're doing, okay?
Yes, sir.
Okay. All right,
And
then you're done.
also,
Mhm.
will my child still be getting Medicaid?
It's up to the Medicaid office.
Okay. Thank you.
All right, ma'am. You can press leave to exit out. Thank you.